I'm going to turn it over briefly to Deja to discuss the recent changes in the CDC eviction moratorium. We recently did a providers training for the NACOA staff, we believe a week or two ago. And at that time, it was pretty much clear that the CDC eviction moratorium would be valid until at least October 3rd, but sadly, things changed yesterday in the other direction.
Yeah, so thank you all. I know that maybe some of you had seen the news. If you had not, the Supreme Court of the United States overturned the CDC moratorium, citing their lack of authority. And so what the ruling basically said is that we need state or congressional action to have a moratorium. There is a group of people in Hawaii that are pushing for a state moratorium, but that is where we're at. So please just try to stay updated. But for the time being, then we just think the best thing to do is get out the information to everyone about the changes in the landlord tenant code that happened as part of the legislative session. What's most important for you to know is that there is a longer written notice that's required. Previously, there was a 5-day notice. It's now 15 days. And that the notices must be sent to the tenant and then also filed with the mediation center. And so mediation is going to be what we're stressing. It's an out-of-court process. Previously, mediation was available after the filing of the court document by the landlord. Now that has been moved. So the best part of mediation is that you will avoid something on your record. Those who have notices need to contact the mediation center immediately. And in fact, we think if you don't even have a notice, if someone's behind in rent, they're having trouble getting that rental assistance, as we were talking about previously, contact the mediation center as soon as possible and just let them know we want to schedule mediation with our landlord. We do not want this to go to court and see what they can do. And so the mediation center will have that notice. It's free. Language access is available. They have a specific line, and then there are translations. The next slide will just give you a brief example. Maybe these translations about mediation are something that you want to print out and give to people. And those are available online. And that's what we want to stress at this time. We've been told that mediation is going to be a way for people to hopefully get kind of a push and in with the rental assistance. So as soon as someone can document that they applied for the rental assistance and they're going into mediation and trying to get that back rent cured through the rental assistance and tell the landlord, I did what I could, I applied for it. And so that information is on the slides, the flyers that you can pass out and give to patients.
Thanks,
I'll turn it over to Fernando. Yeah.
Thanks, Deja. So yeah, unfortunately, a lot of changes in the law literally within the last 24 hours that don't necessarily work in our favor or our client's favor, your patient's favor. But as Deja mentioned, there is a pretty robust mediation option that is available. Some of you folks have already, consulted with me on this issue. So we kind of wanted to share some general pre-screening questions that you folks can use, in your practice if you have a patient walk in with some of these issues, just some things to kind of flag in the back of your mind. And in an ideal situation, which may not always, be the reality, this patient would also be working with an outreach representative throughout this process. So that could be someone through NACOA or some other, third-party person to help them kind of reach out to the mediation center if it's not our group ourselves. So the first question you want to ask yourself is to kind of distinguish whether or not this eviction is based on non-payment of rent or some other issue. So if you determine, okay, it's clear this person's behind 4 to 5 months, it's clearly monetarily based, then the first course of action would be to contact the mediation center as soon as possible if they haven't already done so, or at least instruct them to do that. As Deja mentioned, from what we're hearing, the mediation center does have some resources to provide coverage for back rent with up to 3 months of back rent payments and up to future payments covering 3 months, $2,500 per month. So quite a bit of money. So if it's a purely money-based eviction, do that as soon as possible, and we can definitely, get involved if necessary. However, oftentimes it's not always so clear. It could be a mixed situation. And by that, I mean, maybe they're sprinkling in some house rule violations or something more serious like criminal activity or claims of property destruction, So in that situation, it may not be a situation that is, that can be saved, unfortunately. But when it's something more minimal, you should be asking yourself, do these violations seem legitimate? Are they more focused and kind of critical about the house rule violations, or are we talking primarily about money? And on our side of the picture, are the violations, defensible? If we're talking about something like severe criminal activity that led to arrest and independent criminal charges, then chances are, because there's a lower burden of proof in civil cases, that may not be a type of claim that can theoretically be pursued. Of course, everything is on a case-by-case basis, but things can kind of pop out to you relatively quickly when you're reviewing these cases. The second question, which oftentimes doesn't get asked, is, does the tenant even want to stay in the unit? There's nothing in the law that mandates, as of right now, that a landlord has to indefinitely, provide a lease to a person if the lease term has ended. But, based on the situation and I guess the level of conflict between the parties, tenant might not even want to stay there. But if the tenant does, want to continue to live there, then the first course of action would be, of course, to contact the mediation center to see if you can start up with the rent relief and negotiation process, and perhaps to get us involved as well. If not, there's always an option to work with the landlord and negotiate with them, with the assistance of the mediation center or not, to agree on a mutually acceptable move-out date and hopefully wipe the slate clean. Once you're in the mediation process, obviously important to gather, scan all relevant documents. It could be the lease, agreement, eviction notice, notice of default, house rule violations, ledgers, balances, receipts, anything that they have in their possession. And they may not come to you on the first appointment with all that information, but it's always helpful to kind of prime in their minds, hey, gather everything that you can. Will help to kind of scan things, or at least turn it over to some of the outreach staff or to MLP, because at some point, those documents will need to be provided. If a mediation has already been scheduled, obviously attend that session, respond to all communications from the mediation center. I believe early on they were offering potentially in-person services. I highly doubt that that's going to continue to happen given the surge. My guess is that they'll transition almost entirely to Zoom and also to phone appointments. So I'm not sure how they're going to receive documents that the parties want to submit. But nonetheless, so long as someone has them on the side of the tenant, that would definitely be helpful. They also offer independent language access assistance. So if that's a concern, then definitely want to note that request as well. And then, as you folks always are, as they're treating providers, just continue to be available to tenants as an additional resource or liaison and point of contact. Sometimes, say, once we're able to make the referral, you folks might be seeing the clients more often than we do, or might be hearing from them more often. So they might come to you with a document and say, hey, is it possible if you can send this over to MLP? And that's always helpful as well. And as I stated in slides previously, you're always free to consult with us through either a formal consultation or through something more brief and anonymous, such as a curbside consultation. And of course, if the case requires more of a heavy hand intensive review, we can vet the case by reviewing all the documents that you folks are able to gather, and be updated on any updates in the mediation or pre-mediation process. And Deja will kind of move on now to kind of discuss some other pre-screening issues that you folks can implement in your practice.
So these are the cases that are going to be something that is maybe where legal intervention can assist. And so these are things just to let you know that they are allowed. It's maybe not something that will raise as big of a red flag. So the first would be if a landlord gives a patient a letter to vacate their unit within 45 days and they're on a month-to-month lease. So for example, they signed a long-term lease, it's converted to month-to-month, they haven't signed anything new in a long time. This was previously not allowed as part of the state moratorium. It was never covered under the CDC moratorium. It is going to be allowed. So landlords can just tell someone, I'm not going to make any allegations about you being behind on rent or any rule violations. I just want you to move. So that is allowed. We are aware that landlords may be able to do just give someone a 45-day notice to leave and just wash their hands of any back rent. As long as they're not making any allegations about back rent or rent owed, and they're just saying you need to leave, that is allowed. If the person wants to, we can talk about assisting with mediation for a move out date, but there's not going to be a lot that we can do on a legal perspective to keep that client in the house or have the patient fight something if it's just a landlord saying they need to leave without cause. The next one is if a patient's behind on rent and wants to apply for rental assistance. We would suggest to do assist with navigation to the social service providers. Like Fernando mentioned, we'd also done a big training with NACOA about where those rental assistants are. And we have a slide about this later so that you can know, but it's just more about navigating people to those rental assistance portals. We do understand that it's been very difficult for people to get that assistance. And so we know it's hard not to get expectations up, but there is kind of little legal intervention we can do for getting that rental assistance access, except stressing that mediation can be an access point to those assistance dollars. And then the last one is if these are the ones that Fernando kind of more talked about, which is if a patient gets a notice because of unpaid rent and they have mediation that they need to schedule, to assist with gathering those documents, responding to the mediation notices, and then we're available for those curbside consultations or just talking to us. And we really know this is a new process for everyone involved: the mediation center, the courts, the landlord attorneys, us as attorneys. And so please be involved in sharing with us what's going on. And these are the cases that we definitely want to know what's happening and be aware if issues are developing. So the rental assistance program, this is a general overview. We did train NACOA about how to access them and what some of the access points will be. There are two specific types of rental assistance, and we strongly recommend people to go for the emergency rental assistance. We know for the island of Oahu, the portal is closed. They just recently accepted 5,000. Now they're going to process those. You can sign up for notifications. We will send out something when it reopens. But those rental assistance funds are for COVID only. The other assistance funds that are available, which we're probably going to start seeing people want to access, and we've already seen, I think, one client or maybe two access these funds. These funds are not COVID related. They've always been available, but with some COVID funding have been boosted. And they are specifically for people who are facing an eviction and have a paper or a letter showing that they are going to be facing an eviction process. So before, a lot of people did not have those letters yet. And so these funds were inaccessible to them, or they just didn't need to rely on them. People can call 211, or we've worked with the Office of the Governor's Coordinator on Homelessness to put all of the numbers statewide for every program that has those funds, and they're specifically for security deposits, or we're saying shallow subsidies, meaning someone can get us to move into a new unit or maybe just a little bit of their back rent paid so that they're not moving into a shelter, that they're actually doing an eviction prevention or they're diverting to other housing. And those are available online at that website location. I'll let, I think, Fernando take it. Oh, we've also done, and these were recently updated today to reflect the CDC moratorium. We have some slides that you can share on social media that have some commonly asked questions, as well as just making people know. We're worried that a lot of people will think that if they get a written notice from their landlord, it means they have to be evicted immediately, and that's incorrect. No one can evict you without a court order, but there are a process that you can go through mediation, which could access rental assistance, as well as try to work with some of these other programs to move into a different unit. And so these are slides that you can share as resources, and we will, I think we're going to email those out after this. If there's some other questions you would like for us to add, we can do that as well. And it does have the date on the bottom so that you can know when they were last updated. So we did want to stress that this is new to all of us. As you know, yesterday the CDC moratorium was overturned. And so I know there's a push to get a state moratorium overturned. We talked specifically as well, I think on the 25th, the Department of the Treasury released new guidance about rental assistance to say that for those who don't have cooperating landlords, the rental assistance can be given in direct payments. And so we want you to feel like this is a knowledge sharing between all of us as we kind of share the experiences and understand what's going on.